Okay. Now, I am going to be honest and say I haven't gone and recovered home office expenses because I think this was done ad nauseum last year between specialist tax faculty sessions. We covered it in quite a lot of the tax cafe different sessions. It really was covered in quite a bit of detail too. So I'm not going to go over the minutiae and the nuts and bolts unless there's a specific question. Right. But what I do want to cover is that, yes, absolutely, Section 23B and Section 23M are still around, they're still available. Nothing's changed since last year on that front. So we just continue with what we've done previously. Okay. From my point of view, it is one of those, though, where unfortunately they still haven't given us the updated guidance on it. All right. Which is Yeah, which is the problem. Look, we also have Tuesday. So we also have Wednesday, which is the budget speech coming through. And we'll have to wait and see to see if there's anything new that comes through as an update on home office expenses from that. I don't have a crystal ball. Mine's currently broken. I'm expecting something on solar to come through on it. But otherwise, there's been no legislative change. With regards to the home office expenses. So whatever you did last year is what you can do in the current period. All right. And what you can do going forward. Short of there being a legislative change, which they made next year, but that's also because it's a legislative change, they're not going to be able to do that or have that be effective before probably June, July this year at the earliest. Okay. What expenses can you not deduct? Right, there were some comments about water not being allowed as an expense. I struggle to see why water wouldn't be allowed because ultimately you need water for a functioning office. I mean, it's a basic hygiene issue. Um, I will say what SARS, remember, had said under the previous is that they wouldn't consider is excessive costs. So you'd have to prorata everything to the floor space of your home office relative to the rest of your building. Okay. Um, but other than that, yes, you can claim. There was a yes, but you see, this is also where we have a problem in that SARS has issued that interpretation note. This is part of the issues which were raised last year, where under their interpretation, they disallowed the solar panels and they disallowed Section 24J. So your interest on bond from deduction for your home office expenses. I honestly have no idea why they are saying you can't deduct sewage, refuse removal, and water for your home office expense because you need that for your home office to run. Okay, they might argue the deduction, but I don't know on what legal grounds they're telling you not to. Okay, anyway, but coming back to the interest and the solar panels, this is that particular SARS interpretation with regards to the interest expense and the solar panels in particular was challenged extensively by all of the RCBs. And essentially, SARS was told the interpretation was wrong. Okay. That most of the RCBs do not agree with the interpretation as to why they disallowed 12B and 24J and went and said, and even then it creates an absurdity because how is it that I'm being penalized for owning my own home? Because in terms of their interpretation, if I'm renting, I can claim the cost of the office, but if I own, the interest is not. That doesn't make any logical sense. And in addition, my sewage, refuse removal, and water would be part of my rental cost otherwise. It doesn't make sense. And SARS had kind of conceded that there was a problem with that interpretation, but they haven't reissued the interpretation note. Right. Please bear in mind that from a legal point of view, the interpretation note does not carry any legal weight in the sense that the interpretation note is not binding on us in terms of legal precedent like like a court case. It is merely an indication or a statement by SARS as to their understanding of prevailing practice and their interpretation of law. So, as such, you can still go and deduct the interest expense and the solar panels. All it means is that more than likely, if you put those through, then SARS will challenge you on them, and you'd have to go to tax board and or tax court to make sure that they deducted. But it doesn't mean that SARS's interpretation is correct, right? I always view it as the prudent case, yeah, in the sense that if the interpretation note is the sense check of how easy is this deduction I'm trying to claim going to be. If my interpretation agrees with the interpretation note, then it becomes pretty easy because SARS kind of agrees with me. But if there's a difference, then obviously I have to know that I'm in for a fight. Right. There's a follow-up question here. It says, I have a case where SARS doesn't want to allow expenses not in the taxpayer's name, as the property is in the name of her husband, and as a consequence, all of the property-related expenses are as well. Right. I find this unfair, but not sure how to challenge this. Right. This, excuse me, that's one thing I didn't apologize for. I do have a cold, so if I sound like I'm talking through a tunnel, I do apologize for that. It's still the very stuffy nose. Please remember that Section 11 Cap A, which is what we're claiming our home office expenses under, makes it very clear that the expenditure must be actually incurred by the taxpayer. Okay. The issue that we then have is that if I have a situation where the house doesn't belong to me, then by definition, you can't, the expenses related to the running of the house are by default not going to be mine. It's in the same way I don't go and pay petrol for a car I don't own. I don't go and pay the repairs and maintenance for a vehicle I don't own. So if you do have a situation where the house is in the name of the person who is not trying to claim the home office expenses, the only way you can realistically claim those home office expenses is if you can demonstrate some form of agreement between the homeowner and the individual. So, for example, let's look at my office, presume the house was owned by my spouse, then I would need an agreement between myself and my spouse saying, where my spouse goes and says, hi, I am the owner of address, blah, 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 and basically have some form of like very simple rental agreement or cost sharing agreement where I can demonstrate that I will pay 50% of all the expenses. Right. But if you're going to go that route, then you really do need to have the paperwork to actually match that as well. You need to be able to show that you actually have gone and paid for those for those particular expenses. So yes, you can then go and get the husband to go, well, in my case, my husband could charge me an invoice for my home office, and then I could claim that as a deduction. Now, obviously, it means my husband would have to reflect rental income. However, if you're just doing a straight recharge type agreement, that's going to come out in the wash in his particular tax return. The other thing is that what you need to remember in this case is that's not going to be an option if you're married in community of property, because if you're married in community of property, you own everything 50-50 anyway. But in the case that you married in community of property, SARS can't go and disallow the expenses simply because they then own you in the name of your husband. Because you married in community of property, the asset is jointly owned, therefore it's a joint expense. Right. So that's why the community of property kind of the problem resolves itself almost to an extent. Okay. In all of these, yes, also please remember that by charging that rental agreement, but this is true of any of the home office expenses, then you are going to lose a portion of your primary residence exclusion because you are making essentially by claiming home office expenses, you're making a declaration that the home is being used for trade purposes. Okay. Now, the agreement about the rental, whether that's husband, wife, spouse, mother-in-law, brother-in-law, or anybody else, the principle remains is if I don't own the home and if the invoices aren't my name, then I need an agreement with the homeowner to show the expenses. Okay. The last point I'm going to make on home office expenses is to also just remind you that the quantum of these, in most cases, you really need to ask yourself the question, is it going to be worthwhile given the hassle, given the loss in the primary residence exclusion, and the duration you're actually going to be using it as an office for? Because remember, especially now that the COVID restrictions have been lifted, unless you are commission based, you can only claim home office expenses if you are working solely from home. So I challenge most people as to whether they genuinely are going to be working from home all the time. Because most companies I'm dealing with at the moment have gone to a hybrid model. And if you're hybrid, you actually don't qualify for home office expenses. Something to think about.